Real Estate 101 with Boyle Team Real Estate.
Hi everyone, it's Marlene Boyle from Boyle Team Real Estate, and we are here with our buyer/sellers series with our next podcast. Our guest today is Jonathan Hager, and Jonathan is from Mac Lawyers. He's a lawyer from the office in Oshawa. That is actually their only office that they have.
That's correct. Yeah.
They are a full-service law firm. They do real estate law, they do wills and estates, they do litigation as well, and commercial and corporate. So if you're looking for a law firm, they are absolutely wonderful to deal with, and so is Jonathan. Welcome, Jonathan.
Thank you very much, Marlene. Thanks for having me.
Thank you. So, Jonathan, can you tell us a little bit about your background and your work history and whatnot?
Sure. Well, believe it or not, I've been practicing now for about 15 years.
Okay.
And I've been a lawyer for about 24.
Okay.
So my work started at the Law Society. So I was investigating other lawyers.
Oh, okay.
And then
That's interesting.
Yeah, exactly. And then I did that for a while, and then I joined Law Pro, which is the insurance arm of the Law Society. So that's
Okay.
where, the lawyers obviously need to carry liability insurance.
Yep.
So I did that for a number of years. And then I actually gravitated to title insurance companies. So I started working with the Law Society's title insurance company, Title Plus.
Okay.
And then from there, I joined Stewart Title as examining counsel. So did that for a while. And then, of course, I started getting into private practice. And my private practice previously was I was doing wills and estate work, corporate commercial, real estate, but I really enjoyed doing real estate. I could really relate to that because obviously you and I buy and sell houses personally ourselves.
Yep.
And so I could really understand what the client was going through. So that I just naturally gravitated to that area. And lo and behold, here I am, and I'm now fully this is all I do. I just concentrate just in real estate.
Great, and we're thankful for that because he's very good at what he does. So yes, and I agree with you, we can relate, because I know even back to my first investment property, I'm not a worrywart at all, and I was lying there in bed thinking, did I do the right thing? The tenant's going to pay the rent, that type of thing.
Yeah.
And now when my clients are buying their first investment property, they go through the same emotions that I went through, and I can help them. It's so much easier once you've been through that.
Yeah.
Right? And just to relax them, calm them down, and it always works
That's
out.
it.
And trust me, once you buy one, you're going to get another one. And and they always trust me, and it works out. But I agree. You kind of go with your experience, right?
And I find too, it's a tangible asset, right?
Mm-hmm.
It's not like, don't get me wrong, like the other lawyers who do corporate commercial in our group, selling shares in a business, all that kind of stuff.
Yeah.
But I can't really relate to that.
Yeah.
I can't relate to a physical house.
Yeah.
Right? It's
Yeah.
like we all live in homes, whether
Yeah.
it be condos, houses, what have you. Some of us have cottages. So all of that is just so much relatable.
Mm-hmm.
And of course, I've done it personally myself in my own life with my family. So to me, it's just something that I can really relate to. And obviously the clients, I think I have a temperament too, where, I try not to stress clients out.
Yes.
If I don't have to.
Which is good for real estate, yes. Yep.
And you tend to be, I'm not going to say a social worker, but you tend to obviously
Wear many hats.
Yes, exactly. So if
Yeah.
you have that kind of, temperament and way of just kind of being able to calm people down, especially when it is a stressful time, because let's face it, a lot of people don't buy and sell on a regular basis. So
Right.
this is a big commitment, a big investment in
For
their
sure,
life.
yes.
So to me, it's you need that person who can just be there for them.
Yeah, that
right?
comfort,
So,
for sure. Yeah, a lot of people haven't
Yeah.
bought. I had one this year, is the longest ever. He was in the house he was in for 75 years.
Wow. Oh
Yeah,
my goodness.
that was the longest. I've had 50 years, 25, 40. But
Yeah.
even if you think 25 years, that's a long time.
That's right.
And the market and all the rules and everything's changed in that time. They don't know what the process is.
That's it, exactly.
Right? So,
exactly.
So it actually works out well because this series is on tips and tricks of closing a real estate transaction. So we'll talk about some of the humps and hurdles that some of the clients go through. So let's start with, one of the first questions is basically, so when the deposit first of all, what would you suggest for a reasonable deposit for a real estate transaction?
Typically, I would say around 5%.
Okay.
I think that's
Which is
probably
standard.
Yeah, I think that's pretty standard these days. Obviously, if it's a unique property and it's like we're talking multi-million-dollar property, then maybe we're going to be asking for maybe slightly higher. But it all depends, right? So
Yeah.
between the parties and what their comfort level is.
Right.
I know if I'm acting for a seller, the more money that a buyer presents to me up front shows to me as a seller that these people are at least committed.
Yes.
And that they want to purchase the property, right?
And they can afford it.
Well, that's the other thing too, Marlene, because I find the lower the deposit, that makes me question whether or not these people actually have the financing,
Yeah.
whether or not they can actually close on the closing date.
Yeah.
So
Or whether they're looking to maybe get out of the deal initially going into the deal.
That's right.
That's happened sometimes. When I see a low deposit, I'm like, So, and I know there are circumstances where we realize some clients obviously can't afford 5% down. First-time home buyers, a lot of investors might have their money tied up in other places. Cash flow isn't there. But for the most part, we know these answers. We're asking these questions to their agent or to them if they're our client.
Right.
You know, why can't you do this amount? And we explain it to the other agents.
Yeah.
You know, we're not putting 5% because, so they understand and they have confidence in
Yeah.
us knowing.
And not only that, Marlene, but I find as well that it's prudent on especially seller agents to ask the buyer agents if they can provide like proof of mortgage financing or a pre-approval letter from the bank.
Yep.
Because that at least then shows in writing, okay, someone's committed to loaning that person the money
Yes.
to help close the transaction. So to me, documentation is key.
Yeah.
I love everything to be in writing
Yeah.
and documented. So
Yeah, no, I agree.
Yeah.
I agree. So the other question I was going to ask about the deposit, and I know this is people think this happens, but they always say, well, if they don't close the transaction, the seller will say, I automatically get their deposit, which is not necessarily true. It basically goes into the trust account. But can you just elaborate a little more? Because this is really the most common thing, the misconception I think people have.
Right. So with a deposit, I mean, you're absolutely right. It does sit in typically the listing agent's brokerage's trust account until either completion or termination of the contract. So if I'm a seller and let's say the buyer can't close, the seller, I often have this, is where they come to me and they say, okay, Jonathan, well, I want the deposit, right? Because the buyer didn't close the transaction, and so I'm entitled to it. And I say, well, not so fast.
Right.
It's not an automatic forfeiture. You actually have to go through a court process, right? Sue the buyer to get either that deposit money back, or the alternative is to come to some sort of agreement where we can establish to the agents that, okay, we're willing to let this buyer off the hook, but we want so much of the buyer's deposit, right? So there's kind of two options there, but I say it's not, unless it's built into the actual agreement itself.
Yeah.
There's actual verbiage that says the seller's entitled to the buyer's deposit.
Yeah.
If the buyer can't close due to
Yeah.
buyer default, then obviously it's not automatic.
Right, and that's, I think, don't you agree, the biggest misconception
Yeah.
out there? And then basically the deposit, what happens if the deal doesn't close? I know they typically will try to do an extension. The problem with these deals, people think, and I'm going to ask you this question as well, and I know with dealing with other agents and other buyers that aren't mine, some buyers think that, oh, well, I signed a real estate contract. The house is closing in 2 months. 2 months comes down the line. Oh, I'm not closing. It's just not that simple. They think that, oh, it's a signed contract. They have to close.
Yeah.
And if they don't, there's serious consequences.
Yeah.
And do you not feel once they find out through the litigation department what the consequences are, they change their tune?
Yeah, I do find that. I mean, not to kind of scare people, but I do get that sometimes, Marlene, where I get clients coming to me, especially buyers, and they just say, well, what are the consequences if I just walk away?
Yeah.
And I say, well, if you walk away, not only can the seller go after your deposits, but they can hold you liable for any damages that they may suffer because you couldn't complete the contract. So, for example, if they now have to relist the property and it takes them 3 to 4 months to now sell it to another buyer, well, what are their carrying costs? You know, they have to maintain insurance, they have to pay utilities, property taxes. So all of that would be the seller's damage claim against the buyer. And then to top it all off, if the seller sells at a loss, right? Sometimes the courts will say, hey, in that case, the buyer is then on the hook for settling the difference as well, right? So I find that when buyers kind of hear that, I think they kind of say, okay, we're going to close. I agree. Right? We're going to try everything in our power to close.
I agree.
So, yeah.
And especially with the changing markets, as everybody knows, house prices last year went up 40%. The buyers are looking, going, "Oh my goodness, I paid that much, and now my house is closing, and it's worth $100,000 less. Oh, I just won't close." Well, it doesn't work that way. And then back to that, the reason I mentioned that was because talking about deposit, in a case where maybe they can't close that day, but they ask for an extension, typically you'll ask for, as a lawyer, you'll ask for a further deposit, which is non-refundable.
Yeah, so depending actually, Marlene, on the nature of the extension, right? If the extension is just for a couple of days, I tend to not even ask for an additional deposit. I try to convince my seller client, look, we're all in this together. You want to sell the house. The buyer wants to buy the house. They just need a couple of days, right?
I agree.
Extend.
Yes.
So in that case, I typically would ask maybe just for some carrying costs to be covered by the buyer. And maybe we'll ask for an additional legal fee just because we're handling the extension.
Right.
And that's the extent of it.
Yeah.
If it's a longer extension, then typically if it's like 2 weeks or longer, I would ask definitely for a further non-refundable deposit from the buyer, because I want to make sure that, again, the buyer's committed to closing the transaction with the seller. And I would also try to negotiate with the buyer's lawyer to have any prior deposits released to my client.
Right, exactly. So that 5% they initially put down, and thus you want the bigger deposit initially, right?
Exactly.
For those types of reasons.
Exactly.
So, a couple other questions that I'd like to ask you is, if we're acting on behalf of a client, and this did happen to me this past year, and one of the clients, or whether it's buyer or seller, one of the parties to the deal passes away. What happens in that situation?
That can be, it's a scary moment, and obviously a very sad moment for the party that's suffering the loss. So in a seller situation, if the party's deceased, typically what I would do, this is even before the contract's signed, I would either talk to the agent, talk to maybe their wills and estates lawyer, and say, has probate been initiated?
Yes, for sure. Yep.
Because I don't like these deals where the probate hasn't even been, like the application hasn't even started yet, but there's a firm closing date. Because then I'm like, you know, can the court process the court application in time to approve the probate so that we can close on time? So that is a bit of an issue. But I do find that most people, if someone has passed and it's in advance of listing their house for sale, they've normally got their ducks in a row. They've been to see a wills and estates lawyer. They've started that process, and then we can get a sense of, okay, when can we establish a closing date, right? But if it happens right in the middle of a transaction, which it has personally happened to me, so in that situation, we kind of have to put the brakes on the deal, and we have to kind of work with the buyer in terms of extending the transaction so that we do have enough time to actually apply for probate.
So, sorry, I should have clarified my question. If there's only one seller and that seller passes prior to closing, what is the procedure?
So the procedure then is we need to look at, hire a wills and estates lawyer right away. Obviously, we have one in our firm. And we look to see if whether or not the probate is necessary. 9 times out of 10, it will be.
Yes.
Okay, because the value of the estate will be greater than $50,000.
Okay.
Now, there is a very it's not a well-used kind of exemption, and it's called first dealings. So that's where if the property was in the registry system, which was the old kind of system for handling title in Ontario, if that was then converted to land titles conversion qualified, I know I'm getting into legal.
No, I understand what you're saying, but the public may not, but yes.
And then, of course, if there's been no intervening transfers, so in other words, the seller who's
has
now
lived
passed,
there a long time.
has lived there a long time, may be able to avoid probate altogether using that exemption.
Yeah.
But again, 99% of the time, probate's going to be required.
So if no probate, the deal would go on and close through the estate, obviously.
Yes.
If probate is deemed necessary, then what would be the next step?
So then we have to actually apply to probate, which means that we're applying to the court to approve if there is a will or not a will.
Right.
Plus, we're also having the court approve the estate trustee. So whoever wants to apply for the probate is actually now going to administer the estate. So we need to apply. It's an application. It usually costs about $2,500, $3,000 to process. And it takes time. So in Durham, to process an application, you're looking at close to 8 weeks. If it's in
that's
Toronto,
shorter now.
Yeah.
Okay, wow. They've sped it up.
Yeah. So they've tried to do that. Again, don't quote me on that because
no, it was like 6 to 8 months. I guess probably during our wonderful COVID times.
Yes,
it was
right.
It was quite slow.
That's right. But I do find, Marlene, anything outside of Durham, like if it's Toronto, it's still 6 to 8 months.
Wow. Okay.
Yeah.
So in that case, basically what we're going to do is we're going to extend the closing. Now the problem, but other than that, it should flow fairly smoothly, I would think, except the extension. Now the problem with that, and I know just, with experience, we have buyers who are pre-approved for a certain amount. They have a 90 or 120 day firm interest rate.
Yeah.
And I had this problem with this actually during this year as well. The agent didn't know it had to go through probate. And I saw it was an estate sale, and I'm like, did it go through probate yet? And they're like, well, I don't think it has to. They didn't know. So my seller's like, well, we'll just wait and extend the closing as it goes along. And I said, but the problem is, if you keep extending on the realtor's side, the buyer's interest rate is now not guaranteed. And this was this year when interest rates were going up.
Yes.
So it would not have worked for my client. They wouldn't have been able to close because they wouldn't have qualified at the higher interest rate.
No.
So you have to be just really careful. That way, if you're extending that, now, if this happened, does this buyer have a right to not, to get out of is there a way they can get out of the contract somehow? Or even the seller?
Yeah, so basically, I mean, the completion date is set, right, in the contract.
Yeah.
And unless there was prior verbiage in the agreement that said the seller had the right to extend, the buyer had the right to extend, then in that situation, if the deal can't close, then technically the seller's in breach of contract, right? So even though they've
So
passed,
they can't get out.
So in which case the buyer then can say, okay, well, I could do one of two things. I can either walk away from the transaction, or I can hold you to that contract, right? But then, of course, the buyer then will have to wait for the probate to continue, right? So,
and I mean, they may have time to wait. Who knows, but
exactly.
Okay, well, that's great. Thanks, Jonathan, for that. That clarifies a lot.
Okay.
So can you explain a little bit, Jonathan, about how the taxes work, the property taxes? Do you have to, as a lawyer, confirm that they're paid up to date, and then you have to give the adjustment at closing? How does that work?
So typically, I would ask my seller client if they have proof of payment, right, for their taxes. And if they do, then I'll ask for that, and then I can show that to the buyer's lawyer and put that on the statement of adjustments.
Right.
But generally speaking, if we're acting for a sale client now, we always order a tax certificate just to be on the safe side, because we want to know right up to the date of closing, as to the penny, what our clients paid for.
Okay.
So we'll do that. Typically on a buying, so if I'm acting for a buyer, I also can rely on title insurance. So the parties don't necessarily have to check for taxes.
Okay.
Because title insurance would compensate my client if there were in fact tax arrears that were discovered
okay.
after closing. But if I'm acting for my buyer client, I wouldn't feel too comfortable with my client kind of coming back to me and saying, hey, why didn't you do your job?
Right.
Why were these tax arrears here?
Right.
Why am I now having to go through title insurance?
And now you have to go through that process
yeah.
of I agree.
Yeah.
I see. Now, now, kind of similar to that, I know because I sell a lot of country property, and we do as a team. I always tell my clients on closing, you have to fill propane tank or your oil tank because they have to have heat, and then the receipt is provided to the lawyer, and then an adjustment is made that way.
That's correct.
Is there a process that you can explain for that, or is it pretty simple that that way?
Pretty straightforward, Marlene, exactly how you mentioned. So typically, again, the buyer will request that the seller fill up the propane tank. Seller does that. Seller provides proof to the buyer's lawyer of that receipt, puts it on the statement of adjustments, and then the buyer pays for that tank.
Right, just so they have heat when they move into the house,
Absolutely,
obviously.
yes.
And I've also had where it's an oil tank, the new buyer moving in, the agent will call me and say, listen, my buyer's converting it over to gas or propane, and we don't want it filled.
Yes, so that also happens too, Marlene, and particularly in the summer months too, right? Because you're not generally going to use any heat, right, for the summer. So sometimes I do get buyer clients telling me, hey, can you mention to the seller, don't fill any of the tanks up, right? Because we don't need it right now.
So that's okay to do that. You don't need anything in
Absolutely.
writing or anything like that. Okay. Yeah. And I figured because we do it all the time. I just didn't know if there's any specific process.
I usually, though, just so you know, I usually document it, and I do advise the other side that this is what our client wants to do, just so there is a bit of a paper trail, so that we, there's no sort of miscommunication.
I agree.
Or,
No one's coming back saying, you said you were going to fill that tank. No,
you
exactly.
got it. You got it.
Exactly. So Jonathan, this is a question I get from my clients all the time, and I always will tell them the lawyer will contact you. So the process is we get the deal, send all the contracts to you as their lawyer if you're, agreeing to represent them. And then what's the next step in your firm? Like, do you call them? Do you email them? Do you meet with them right away?
That's an excellent question, Marlene. So typically, when we do receive a deal in from an agent, we'll definitely, typically I email the client just because I like, again, to document everything, to establish a paper trail. But I always mention to the client initially, look, if you ever have any questions, feel free to either email me or call me.
Right.
I'm happy to do that. So I have clients doing that all the time. But I always like to, as soon as I get the deal in, always like to introduce myself.
Okay, so right away, that's good.
Yeah, absolutely. And let them know, hey, I'm going to be the lawyer. I'm going to be a lawyer on the file from start to finish.
Right.
If you have any questions in the interim, kindly let me know. But otherwise, I will let them know kind of what I need initially too, right? So like if it's a sale transaction, this is what I need from you, you know, proof of tax payments, that sort of thing. If you got an existing mortgage, maybe a mortgage balance statement, that sort of thing. If it's a buyer, I always let them know, hey, can you let your mortgage agent know that I'm acting for you so that they can send the mortgage instructions directly to me? And can you let your insurance broker know so that you can set up property insurance in time for closing and let them know that I'm acting for you as well? So I usually do all of that stuff in advance so that, again, we're not scrambling at the 11th hour trying to wait for documentation from the client. And I find that really works in my practice. And then typically, I say that we're going to send you out our firm's introductory letter, just kind of explaining next steps. And now we also send a link out to them to verify their identification. So we try and do all this stuff ahead of time so that, again, the client has less to worry about and less to think about as we near the closing date.
And then when do you do more virtual signing, or when do you typically have them into the office to sign the final paperwork?
Yeah, again, excellent question, Marlene. So I find if someone's remote, and let's say they work in Toronto, it's difficult for them to come in, provided that, let's say it's a buyer client, provided that they're mortgage company allows for virtual signing, I
Okay.
will do it via virtual.
Okay.
So about 50% of my appointments now are done virtually,
Okay.
and 50% are done in office.
So some lender companies don't allow that. See, I didn't know that.
Yeah.
That's interesting.
Particularly private ones,
Yeah.
they really don't like it at all. Yeah.
Okay, which makes sense. And then, so for their final signing, what point before closing would they come in? Like a week or so, usually?
I usually do that. Maybe I like to do it as much time in advance as I can. But typically, you know, banks and stuff, you know, everyone's working hard
Yes,
these days,
yeah.
and things get delayed.
Yeah.
So we typically find that we get the instructions maybe a week before closing.
Yeah.
And then we're calling the client in to see us maybe 2 or 3 days.
Okay.
prior to
Oh, wow.
closing.
Okay. Yeah. And I know
Yeah.
some are like that. And
Yeah.
that's when I get the calls. Like, I haven't heard. But now you guys are really good. Like, you always are keeping them up to date.
Absolutely.
But sometimes I'll get, I haven't heard from the lawyer. Am I going in? And I said, yeah, let me just call them. But a lot of times, you know, I know everybody gets busy, as you say, and it's
Well-
just usually more closer to the end where they
Exactly.
sign.
And that's one of the things I love about working with you, Marlene, is that
thank
you
you.
are very receptive and you are so approachable and there for the client, right? So if a client has a question, you answer it. You get in
Thank
touch
you.
with them right away. And I
Yeah.
like to think that I'm the same way
You are
too,
for sure.
right?
That's why I
So-
think we connect very well.
Good
Yeah.
team.
Yeah,
Yeah.
excellent. I just want to thank you, Jonathan, for participating with us today and sharing your knowledge. And I'm sure everybody really appreciates it and has taken a lot from it. I just want to end with, do you have any suggestions for, you know, clients, the public, everybody watching, the audience, of any type of information they should, you know, any books or any websites they can go to research, you know, closing transactions or about real estate in general?
Yeah, no, for sure, Marlene. Well, first of all, I want to thank you for having me. It's been a pleasure. Very interesting discussion that we've had. Second of all, I just want to mention to everyone who's listening to us and watching us
Yep.
that my comments obviously are personal. They're just personal opinions
Yep.
to me, not necessarily to be construed as legal advice. So I always recommend that people do their own investigations.
Yeah.
You know, talk to your lawyer. Hopefully it's me.
Yeah.
But at the same time, if you want more information, the Law Society website, so lso.ca,
Okay.
.on.ca is really good. The other websites to go to if you're a new, like let's say you're purchasing from a builder, is the Tarion program,
Yes.
the warranty program.
Yeah.
So
And that's a whole
Tarion-
conversation on its own. Yes,
whole
maybe we'll do
separate-
that one.
Yeah,
next.
absolutely, absolutely. But Tarion.com is that. But you can find a lot of stuff just Googling,
Yeah.
which is what I find.
Yeah.
So, and of course, our website, we've got a lot of information on that too, which is www.maclawyers.ca.
Great.
Yeah.
Well, thank you so much, Jonathan, and thanks for everybody for watching, and everybody have a great day.